Cohen's vision, I think, still stands true today, and there have been some subsequent U.S. Supreme Court cases that I will touch briefly upon that have further constricted some aspects of sovereignty, and in particular the doctrine of tribal sovereign immunity and external powers and controls over non-Indians in their courts. Because Indian tribes are mentioned 3 times in the U.S. Constitution, an inordinate number of cases go to the U.S. Supreme Court every year. During the 1910s through the 20s, fully 1/3 of the U.S. Supreme Court's docket involved Indian law cases. And some of that had to do with the formation of Oklahoma from Indian Territory, and a number of laws that were passed that dealt with the allotment era and the assimilation of Indians and their properties through that time period. Just to give you an idea about the U.S. Supreme Court, every year it receives approximately 5,000 requests for it to hear cases, and that's called grants of certiorari. And the U.S. Supreme Court has discretion about whether to accept cases or not. And they usually only accept a case under 2 circumstances. First, if there's a conflict between federal courts within the United States and they need to bring cohesion on a question of law. Or second, it involves an important constitutional issue, and the U.S. Supreme Court has total discretion on the number of the cases that it will hear. On average, out of the 5,000 or so requests, the U.S. Supreme Court only hears about 80 cases. And in recent decades, the Supreme Court will, in every docket, will hear about 4, 5, or 6 federal Indian law cases. It has been a swinging pendulum on the Supreme Court on how it's treated Native Americans. While Congress has plenary power over Indian policy and Indian law, courts have had a very important role in shaping the contours of tribal sovereignty, particularly with the judge-made doctrine of tribal sovereign immunity. Some of the recent cases, like the Bay Mills case that we touched upon earlier, deal with issues such as land into trust and the power of the United States to place land into trust, take it off the tax rolls, and protect it exclusively for the use and benefit of Indian tribes for self-government and to the exclusion of state powers. There are a few cases that I'd like to start with that deal with the Cherokee Nation in the early part of our nation's history. There's the Marshall Trilogy of cases, and that's John Marshall in the 1820s and 1830s, the first Chief Justice of the United States. And Worcester versus Georgia, 1832 case was one of those cases. And Johnson versus McIntosh, the 1823 case. Johnson versus McIntosh was kind of a dark case in which the U.S. Supreme Court had occasion to come up with the theory and the doctrine of title by conquest. That is, European settlers coming to the United States by virtue of conquest could take title in their own name, even though Indian tribes and Indian individuals had aboriginal title. Many scholars and commentators have called that a very dark period of history and a dark concept that informed federal Indian law to this day. One of the more brave and courageous decisions of the Supreme Court shortly thereafter, just 9 years later, was Worcester versus Georgia. And in that case, the U.S. Supreme Court, by Justice Marshall, came up with the concept of distinct independent political communities, that Indian tribes are domestic dependent nations, and that they stand apart from the states and that they have their own sovereignty. And in that decision, the Supreme Court ordered that Georgia has no jurisdiction over the Cherokee Nation within Georgia. Unfortunately, though, at that time, the executive branch of the United States, Andrew Jackson, refused to recognize and enforce the decision of the U.S. Supreme Court. And President Andrew Jackson is reported to have famously said that John Marshall has made his decision and now let him enforce it. Georgia didn't enforce it, and the Cherokees were led on the very unfortunate and tragic Trail of Tears that resulted in a major removal and genocide of a number of people being forced out of Georgia and relocated here to Oklahoma, and losing much of their population in transit to disease, starvation, cold weather, and wretched conditions, inadequate supplies. This doctrine of conquest has dominated that part of history, and it is also characterized by concepts of manifest destiny, which I'm sure all of you have learned in your history books is the mantra of settling the West and winning the West. But to Indian people, manifest destiny is somewhat of a dark and evil concept of colonization and conquest of their lands. It is a concept of sorrow that Native peoples still feel to this day. Let me move forward with some more cases from legal history, and that is during this time period of 1832 in the Marshall Trilogy. That was a removal time period in which tribes were basically forced west and away from burgeoning population centers and onto reservations. It was a period of treaties that were made with tribes to have peace, and after that time, a number of tribes settled onto reservations, and thereafter, there were some tribes, though, that, like the Comanches, that refused to settle onto reservations and accept that type of lifestyle. And there was a period of war during that time period in the mid to late 1800s. During that time period, the War Department was responsible for not only the Civil War, but also concurrently wars against Indian tribes. And the largest mass execution in the history of the United States involved Indians during the Lincoln administration in the 1860s in Minnesota, where hundreds of Indians were executed up there from some of the northern tribes. Thereafter, in 1866, the Cherokee Nation entered into a treaty, and that treaty is still being litigated today. In particular, some of the freedmen issues. There's a case pending in the U.S. District Court in Northern District of Oklahoma and the District of Columbia. And there'll be oral arguments next month, I believe, in one of those cases. So some of those old treaties are still at issue. And some of those treaties still contain rights that are very important to Indian tribes and their government. Believe it or not, it wasn't until the 1880s that courts considered Native Americans to be human. Before that time, under the law, Indians were not considered human beings. In 1896, the U.S. Supreme Court decided a case that involved the Cherokee Nation called Talton versus Mays. And that case held that the United States Constitution's Fifth Amendment did not apply to the Cherokee Nation judiciary, and that it stood outside of the Constitution, and that Cherokee courts were not subject to the Fifth Amendment powers of the federal courts. Another early case is Ex parte Crow Dog from 1883. And Ex parte Crow Dog dealt with a Lakota person that was had murdered another Lakota, and the tribe tried that person, and was the custom among the Lakota people. Crow Dog was ordered to not to hang by the neck, but rather he was ordered to go work and provide for the family of the person that he murdered. And this was a custom to atone and rehabilitate and bring peace within the tribe. Well, the United States was livid about that decision and thought that Crow Dog should be hung and executed for the murder. So it brought a case, and Ex parte Crow Dog went to the U.S. Supreme Court, and it held that it was exclusive jurisdiction of the tribe to try Crow Dog under their laws. Congress responded some years later with the Major Crimes Act, which made it a federal offense to commit certain crimes on Indian country, and vested that jurisdiction in federal court. And that was an example of Congress passing a statute that took away some powers of Indian tribes, to try major crimes for themselves. As was mentioned earlier by Chief Baker and his father or grandfather not being able to vote, Congress didn't pass a law until 1923 that made Native Americans citizens of the United States so that they could vote. Another important case was Santa Clara Pueblo versus Martinez, a case from 1976 that the U.S. Supreme Court held that the Indian Civil Rights Act of 1968 didn't allow people to sue in federal court for the vindication of those federal rights, and that the sole remedy in federal court for a violation of the Indian civil rights under the Constitution and under that federal law was for habeas corpus. The tribes were left with the power to and the discretion to decide for themselves internal relations such as citizenship that was at issue in Santa Clara Pueblo. In the Cherokee intermarriage cases of 1906, the U.S. Supreme Court also had respect for tribal law and the determination of domestic relations. There were a number of different eras. As I mentioned, Congress has had a swinging pendulum of policies of the removal era, reservations, war, the General Allotment Act, breaking up the tribal landmass, which dispossessed over 50 million acres from, or 100 million acres from Indian tribes by the stroke of a pen, and putting it to individuals so that it could be alienated. And the new policy of the Indian Reorganization Act of the 1930s and its counterpart, the Oklahoma Indian Welfare Act, which allowed for tribes to reorganize under federal law. There was another dark period where the pendulum swung back again during the 1950s, and it was called the Termination Era. And during that era, Congress passed a number of laws that, by the stroke of a pen, struck certain tribes out of existence and said that you no longer exist, and you're no longer a tribe, and you're no longer Indian. And that was a very hurtful period, and that was also a period of massive assimilation when a lot of Indian families were broken up and kids were taken away and sent to boarding schools. Indian kids were adopted out to non-Indian families, and it was another time period of hurt. I mentioned the 1960s, and the termination period sort of came to a close at that time period, and under the Nixon administration, the Self-Determination and Education Assistance Act was passed by Congress, And that is a law that still has very much force and power to this day of self-determination. And it is the prevailing policy and sentiment of federal policy today. As was mentioned by Jeffrey Cartmel and others, we have had different Supreme Courts and different eras of treatment of Indian tribes. During the Warren Court, and there was a great resurgence of the recognition of tribal governmental powers and respecting self-government. Some of that was taken away during the Rehnquist Court, and there were a number of cases that were decided at that time which dealt with limiting the powers of tribes and tribal courts over non-Indians in particular and non-citizens. There was a case called Olifant versus Suquamish tribe from 1978 that the U.S. Supreme Court said that Indian tribes lack criminal jurisdiction over non-Indians. And just another year, or several years later, the U.S. Supreme Court decided a case called Montana versus United States that dealt with hunting and fishing powers of an Indian tribe on a reservation and whether the tribe could impose restrictions on non-Indians on their fee land within the boundaries of a reservation. And the U.S. Supreme Court said that, as a general matter, the Indian tribes lack the external power to regulate non-Indians, except for two exceptions. The first deals with consensual relationships through treaties, or leases, contracts, taxation, or other relations. And the second is through if certain conduct of non-Indians imperils the self-government of the tribe, the health, safety, and welfare of the tribe. There have been a series of cases that have followed since that time. Durov versus Rana that said that Indian tribes don't have jurisdiction over non-citizens, Indians. Just a few years later, Congress responded with a law that was called the Durov Fix that said that tribes can assert jurisdiction over Indians that live within the reservation and live within Indian country. And then there were several other cases, Nevada versus Hicks, Strait versus A1 contractors from 2001 and 1997, respectively, that further limited the powers of Indian tribes over non-Indians. Congress has also passed certain laws that have expanded the powers of Indian tribes greatly. One, I mentioned the taking kids away from Indian families and placing them with non-Indians. In 1978, Congress passed the Indian Child Welfare Act, which greatly strengthened the power of tribes to take care of their kids, and kids placed for adoptions could be placed with Indian families and kept with Indian culture. And that was one of the most powerful acts to give power back to tribes over Indian families. Just last year, Congress passed the Violence Against Women's Act, which gave Indian tribal courts powers over non-members that are in domestic relationships with Indian spouses and relatives. And that was also another important one. I'm going to wrap up my comments now and just say that I really appreciated the compact panel, and I believe that there are great opportunities for tribes and the state to work together on issues of common interest and to reach some of the same goals that were mentioned of economic development and protecting our citizens with issues of mutual interest.